Do we need an interpreter? And that's an F. DA and CTX.
Okay, I'm sorry to keep you waiting. You ready?
Sure.
Okay, please. Mr. Williams, come on up, sir.
Other way. Go by
Yes. Okay, we're doing arraignments first and then I can help you with the.
So.
Okay.
I'll miss the docket.
Good morning, Mr. Williams. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
Thank you, Judge. On Interstate 2025 in Harris County, Texas, officers were dispatched to disturbance. Officers made contact with the defendant who had blood on his face, near his beard and lips, and denied that anything was happening. The officers then met with the complaining witness who had a large wound on the bridge of her nose and was still bleeding. Officers also observed blood on the hood of the car. The complaining witness said that the defendant is her boyfriend who had come home and started asking her, where is the other guy at? And then proceeded to punch the complaining witness in the face, causing bleeding. That's it? Yes, Your Honor.
Okay. All right, sir, I'm going to find that there's sufficient probable cause to go forward with the case. There's a protective order that has been issued in this case. Get to know it. If you do something to violate the protective order, the state can and probably will file a violation of protective order. It's one of the worst cases you can pick up. At this point, do we know whether she wants to have contact with him or not?
You just have one moment, Your Honor. There's a rip call.
I don't know if she wants to have contact with you or not. Until we know whether she does, I want to honor her wishes. If she doesn't want to have contact with you, I'm going to order you not to have contact with her. If she does, then we can modify the conditions. I just don't know at this point.
Your Honor, may I say, I spoke with her, as a matter of fact, yesterday. She reached out to me because she wanted to do an affidavit of non-prosecution, and she wanted this case to be dismissed, and she did want to have contact. Of course, I advised my client that there's a protective order in place, so regardless of what she wants, unless the judge gives permission, he couldn't. But from my understanding.
The state can confirm that, Your Honor.
You can confirm?
Wants contacts.
Okay, so I am going to order you at this point not to have any threatening or harassing contact with her. You need to understand that what is threatening or harassing doesn't matter what you think. I don't care what you think. It's what she perceives. So if you go like this to her, that is most certainly threatening, harassing, and it can land you right back in jail. There's a lot of vindictive people in this life, and I don't know what kind of relationship you have with her. But if it's something that you're constantly butting heads, I'd be very careful because she calls and makes the slightest, you're the one that's going to end up back in there. Do you understand? All right. So what we'll have you do?
That's a different thing. I have different.
Oh, this is not that. So I'll modify the bond condition. What I'm going to do is I'm going to take off the residential restriction. However, everything in this order still applies and it's stuff that you shouldn't do anyways. So make sure you read it and know what it is. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with her. If she tells you that she can't get a hold of you because you're playing games, you pick up a new case or you become a danger to my community, it's not going to go well for you. Do you understand? Good. I hope so. All right. So we'll have you sign a reset. Don't leave until you sign our bond conditions. And after that, you'll be free to go. Thank you. Yes, ma'am.
Thank you, sir.
So can you file no threatening or harassing, please?
Yes, Your Honor. No weapons.
And no weapons, right?
It looks like Attorney Wilkworth will want me to sign. So that's a print out copy of the law that the defendant signed with the prosecution line. It's very small.
Yeah, okay. I mean, as long as he signed, I'm good. Thank you. Okay.
You will need to come in.
Sorry, I didn't know this.
You'll need to come in and sign for a new law on the previous case, because the one that he signed previously in February already expired.
Okay.
You
Ready?
Yes.
Okay.
All right, Judge, page 17, Fuller. Fuller, come on up. For this one, there was a co-defendant Allen. Can I get the case number for that one?
Yes, ma'am.
How old are you, Mr. Pullard? Okay. Are you here with anyone today? What, do you have the cause number for the co-defendant?
Yes, Your Honor. Sorry, so working on it. The cause number, Your Honor, is going to be 255-9110. And 255-9112.
They're disposed.
I'm sorry, Your Honor. Yes, Your Honor, that's correct, but those cases have been dismissed.
Okay. Mr. Pullard, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 7, 2025, in Harris County, Texas, officers theft of chocolate gave a call and an off-duty officer who had detained the defendant and a co-defendant. The off-duty officer was informed by mall security that the co-defendant had stolen merchandise from Zoomies and passed all points of sale and ran out of the store. The co-defendant then ran to a car in the parking lot where the defendant and another individual were located. He blocked in the vehicle and were able to detain the defendant and the co-defendant. Officers found a handgun in the glove compartment of the vehicle. Didn't say the handgun belonged to him. And the officers observed a strong odor of marijuana.
The officers what?
Observed the strong odor of marijuana.
Okay.
The defendant did state he had weed or marijuana in his pocket. The officers retrieved a bag of a leafy green substance from the defendant's pocket.
So he's a passenger though, right? Or was he the driver?
I believe he was the driver. Let me make sure that's correct, Your Honor. He was in the driver's seat. That's correct.
Mr. Pullard, I'm going to find that there's sufficient probable cause to go forward with the case. Can you run his license, please?
Yes, Your Honor.
What do you do in life these days, sir?
I just finished electrician school out in Port Arthur. I just
Great.
recently moved back to Houston.
Did you get your license or no?
Only thing I have from there, the school was like an OSHA 10 certification, but and basic training of electrician, but it's more classes I have to take to
Get
get
on it, doggone it. What are you waiting for? You know?
It's just a lot. I had a lot of family issues going on with like moving back and forth from Houston and Beaumont. Where I was staying at in Beaumont, our house, during the storm, it messed up, but I was only staying out there because of the school. But now our house is getting
Are
repaired.
you living here in Houston now? Okay. I'm going to appoint your lawyer today, Mr. Pollard. I don't want you to get in any more trouble and I don't want you to use. You're not to be in possession of weapons. I'm going to test you 50 days from today. If I find that you're using, it's not going to go well for you. You understand? I don't want you hanging out with the co-defendant in this case as well. You know, you're on a fast track to nowhere. You have the opportunity to get a really good job. Electricians can make, a killing if you do it well and you get on it young. Well, but I'm telling you, this is not a good way to start. Do you understand? So I'm bringing you back in 2 weeks and I want to see what you have done to further your electrician career. Get back into school, so you can get your license. Do you understand?
Your Honor, his driver's license is eligible.
Great. You may drive as long as you have liability insurance as well. You cannot drive unless you have car insurance. Do you understand? I'm making that a condition of your bond as well. Okay, so to test in 50 days, no alcohol, no illegal drugs, and back in 2 weeks to see what he's done for school or work. Okay, all right, I'm gonna appoint your lawyer today. You're gonna sign a reset with Victoria. You'll meet with Anthony for pretrial services, and then we'll have you take a seat in the jury box. Please.
This way. Judge, counsel is approaching for page 20. Santa Fania.
Yeah. Are you doing a plea?
No, this is an arraignment, but I also have a plea.
Santimanes?
Is an arraignment.
109 days old.
Yes, apparently, we just got hard on this case. Apparently, he supposed to come to his first setting. But he tells me he couldn't get a ride, so he didn't come. So here we are. He posted a new bond. So it's as though we're starting over. So I just need to look at the discovery and then we'll go from there, Judge. It's a .076 expired.
Mr. Santimanes, you are charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Judge, on December 27, 2024, a law enforcement officer was dispatched to Clear Street and Allenville Road to back up an officer on a traffic stop. Law enforcement officer had stopped the defendant's motor vehicle for expired registration and loud noise and vibration. The law enforcement officer made contact with the defendant, the driver, and the law enforcement officer observed the defendant spraying cologne over his body several times. He also observed the odor of an alcoholic beverage, red watery eyes, slurred speech, and the defendant stated that he was drinking alcohol at an unspecified time with some friends at a trailer park. The defendant's girlfriend requested they meet, which is why he was driving. The defendant consumed 3 bottles of 12-ounce Modelo beer approximately an hour prior to the law enforcement officer contact. Steroid spray tests were administered, and the officer observed 4 to 6 on the HGN, 4 to 8 on the walking turn, 4 to 4 on one leg stand. And while administering the HGN, the defendant had a distinct side-to-side sway.
You say side to side sway?
Correct, Your Honor.
Okay.
During the walking turn, the defendant used his arms for balance for the entire test and hopped to maintain balance for approximately 10 seconds. The defendant consented to a breath test and the .076 and .073.
Okay, Mr. Santibanes, I'm going to find that there's sufficient probable cause to go forward with your case. Any prior to DBIs, does he have a license?
He does not, Your Honor.
No prior to DWIs and his license is
Okay, as long as you have a valid Texas driver license and liability insurance in your name, you may continue to drive. I am ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, it will not go well for you. I will put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they can put an immigration detainer on you and you will be stuck like Chuck in there until this case is over with and then you get shipped off to immigration. Do you understand?
Yes.
So your case is now 109 days old. We don't set cases very long after for trial, so get ready. Do you understand? Okay.
Yes.
I'll have you sign a reset with Victoria. After that, we'll have you meet with pretrial and then you're good to go. Thanks, Marcus.
Thank you, Judge. And then for my plea, you want me to wait?
That was the last arraignment, Judge.
No, okay.
Let's do it. And then I think, Jesse, you have one too. We'll get to hit you.
It's Chirinos, Chirinos. May I call him up?
Chirinos, come up. Actually, Jesse, let's do both of yours. Why not? Yeah. We might as well kill 2 birds with 1 stone.
This is William Hernandez.
Okay? Okay. Gentlemen, this way. Both of them?
Yeah.
Okay, both of them.
Okay, one at a time. Hernandez Quinteros.
Oh, these are. The test results from yesterday. This tested yesterday and going for the day. It is 2534.
La señorita aquí, la interpretando.
Both are true first, right?
Yes, Your Honor.
Interesará si tienes las consecuencias.
Both of you are charged with criminal cases. You're charged with driving while intoxicated. Both of you have breaths over 0.15. That makes it now a Class A misdemeanor. You are facing a year in jail and/or a $4,000 fine. Both of you have negotiated plea bargain agreements for essentially slaps on the wrist. After today, each of you will be facing 90 days in jail for any other DWIs that you pick up. And I will tell you now, if you're ever in a car, you get pulled over, first thing officers do is they look at your record. If they see that you have prior DWIs and they go up to your window and they smell alcohol or dope, it's probably not going to go well for either of you. So if I were you, I would never get into a car and drive, even if you've had a sip of alcohol, because you're taking a huge risk, especially if you're not in this country with permission. Do each of you understand?
Yes, yes, sir.
Minimum of 90 days in jail from now on. No more slaps on the wrist. Both of you give up a lot of rights by entering into these agreements. You're pleading guilty to these charges. They will go on your record. They will be there forever. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. Both of you give up the right to appeal as well, meaning that once you plead guilty, there's no changing. Do each of you understand?
Yes, sir.
Is this what you want to do?
Yes, sir. Yes, sir.
How do you, each of you plead to the offense of driving while intoxicated?
Guilty, sir. Guilty,
I
sir.
want you to understand that everybody makes mistakes. When you continue to make mistakes, when you endanger other people's lives, that's when we really come down hard on you. There is a $4,500 surcharge that would normally apply with these types of cases. I understand that mistakes happen, and I will take it off of you now. But if you make another mistake and you pick up another DWI, a second DWI, it's a surcharge of $6,000. And if you don't pay it, every $100 you owe, you sit 1 day in jail. Not to mention the minimum 90-day sentence that there is. So get a clue. If you want to drink 32 beers, 52 shots of tequila, take an Uber or find another way to get around. Do you understand? I'm going
Yes, sir.
to suspend both of your ability to drive for 90 days. Do not drive. Otherwise, you will be back here. Mr. Chirinos, I'm going to sentence you to 6 days in jail. I will give you credit for the 2 days that you have done. Mr. Hernandez, I'm going to sentence you to 3 days in jail. I will give you credit for the 1 day that you have done. Good luck to you, gentlemen. Thank you, guys.
Vamos.
Sure. Hi. Okay, who's your guy?
Fuentes Lobo, and I got the contract now. They sent the contract this morning. Yeah.
So we'll give you 2.5 weeks.
Okay, appreciate it.
If it's not done by that point, I'm going to bring this person back day for day until they get it
I
done.
told you.
Good.
Okay.
Thanks. Have fun.
Council for reset.
Hey, come on up. Yes. See.
How are you?
Hi.
Mr. Guillermo Gonzalez.
Dallas?
Yes, sir.
Okay.
We're here for an update on the DWI-PTI. We just received the contract. We're gonna be discussing it,
Okay.
signing it, and then I'll be sending it to the DA's office.
So you still have to get the interlock and pay the DA fee, right?
No, I just received the contract. Sitting there, received the contract. So we're gonna be discussing it, signing it, notarizing it, and then I'll be sending it to the DA's office so that they can.
We need
Yeah,
time for the
yes,
interlock.
exactly.
Right, okay,
Yeah,
so we'll
well,
give you 2 weeks.
He'll be signing a no driving affidavit because he doesn't have a driver's license, so
Okay.
he'll get the portable device or the scan, whatever they decide.
Yeah, okay, we'll give you a couple weeks. Okay.
Yes,
thanks, Sylvia.
please, sir.
Yes, ma'am.
Thank you.
Blaze, so are y'all going next door now? Are you?
Yeah, we got a panel coming down now, Your Honor.
Maybe it'll cave, you never
I
know.
don't know when, you know how that goes, but.
Yeah, well, good luck.
Thank you, Your Honor.
Yeah.
Approach.
Hey.
Judge, just approaching on Josue Bueno. He says that he got drug tested yesterday and that his results came back clean. Now, I've not independently verified that, but. Josue Bueno?
Bueno was presumptive negative.
Can I get a standard reset on him, Judge?
EVR was for missing a test, right?
Yes, Judge.
Let him know that and admonish him that if he misses again, I will issue a warrant. But
Yes, Judge. And
standard
he's
reset.
right there in the jury box.
Come up. Stop talking to everyone. Do you understand? Please. If you miss again, it's not going to go well. Do you understand? If they call you, you have to go test. Next time you miss, a warrant issues. Okay, all right, got it.
Judge. I'll go back to.
Good to go? Your Honor, may I approach on another case?
Judge, I've got Zandre Smith. He's set for bond forfeiture today, I believe. I've not been able to get in touch with him
Okay,
unless he appears today.
I'll end up revoking it.
We're waiting to send him to a testing lawyer on it to get here.
Oh, he's testing?
No, if he appears, he hasn't appeared.
Oh, yeah,
I believe he's been failing to report to probation.
right, so did we file a motion to revoke?
For Mr.
Smith?
There's Zandre Smith. There's a current motion to adjudicate, Judge, based on his new law violations.
So I'm gonna revoke all of them then. So on the UCW, yeah, I mean, I'm gonna wait till the end of docket, see if he shows up, but if he doesn't show up by the end of docket, it'll be $15,004 or do 15,004
For which one, Judge?
UCW.
Unlawful carrying.
Yeah, he's on deferred for the unlawful carrying and there's a current motion.
Okay.
On the AFM, 5,004, as with the criminal trespass, 5,004. And then I'll give you a heads up and I'll text you if he ends up showing up.
Yes, Judge, I can always zoom on if, okay, thank you, Judge.
The previous one was in sample last year.
Okay, please.
There's two motions.
I'm here today on Mr. Devontae Bullock. He was the gentleman that was sent over to take a drug test yesterday, and he's returned to court.
Bullock. Next door, I think they are.
Bullock, Your Honor, Bullock was presumptive positive to THC and it's pending a lab confirmation.
Okay.
And he's here in the back of the court.
And he did disclose to us that he had utilized THC recently.
Hello, Mr. Bullock. You now stand charged with another burglary of a motor vehicle. So they now have you on 2 charges of burglary of motor vehicle. I'm telling you that I'm going to do everything in my power to protect my public. I don't care how old you are. I don't care how young you are. You go out there, you start acting a fool. It's not going to go well for you. Do you understand? I just set someone's bond now at nearly $30,000 because they're out there running amok. Don't do it. I'm going to test you 50 days from today. If I find that you continue to use, it's not going to go well for you. Do you understand? We need to do probable cause on the new B&B because we haven't done it. So do you mind? On the new case,
Is that failure to ID?
no. So there is a failure to ID. There's one BMV, and I guess later on in the day goes out and allegedly has another BMV. Okay.
On April 7th, 2025, law enforcement officers were dispatched to a burglary call in Harris County, Texas, and met with the complaining witness, who stated that around 6 a.m. he heard his car alarm going off and observed 2 males wearing all black making entry into his vehicle. Another law enforcement officer that was dispatched to that location observed 2 males matching the description in the same area, and the defendant had complaining witness's key fob on his person that was in the middle console of the vehicle. I believe when they broke it.
So that's how they put him, because he's got someone else's key fob.
Yes, Your Honor.
Okay.
Then he was identified by mobile AFIS.
I think I need to get attached to that third one.
We'll attach you to it now. Yeah. So do you want to file a, I guess another one because he has a new case?
Your
The
Honor,
one in Port 16?
Yeah. Or I guess we need to get it over here. You want to do a transfer? Okay. Yeah. You
That
want
was what I was gonna say. On mine, it was still showing.
Yes. I don't want you out in the middle of the night. I'm going to put a monitor on your ankle so I know where you are at all times. I don't want you to have any contact with the complaining witnesses in this case, and I don't want you to go anywhere where they live. You pick up a 4th case, I'm gonna go haywire. Do you understand? What are you doing with yourself these days?
Nah, I'm gonna finish school and I'll think about joining the military.
Not why you have all these cases open. Did you not get enough sleep last night?
Not really.
While these cases are open, you must either have a job or get back into school full time. When you have too much time on your hands, you become self-destructive. And the days of you just sitting doing nothing are not going to happen. I'm bringing you back in 2 weeks and I want to see what you have done to get a job. If you have done nothing, it's not going to go well for you. Do you understand?
That's not.
Do you have an ID? Okay, I want you to start going applying for as many jobs as you can, or you get back into school. While these cases are open, military is not going to take you. I don't think if that's something that you want to go do, that would be great because that would give you great structure, which you probably really need. I mean, the military would be a fantastic idea for you that would really, could potentially put you on a career path that could just lead you to the clouds, really. What you're doing now, you're charged with 2 counts of burglary. You know what that'll do to your career? Who hires burglars? No. You think you won't even get financial aid with that kind of stuff? Really, it will hose your whole career. So for now, you must either get a full-time job, start looking into going back into school, but you doing nothing, it's not gonna happen. Do you understand? All right, so what we'll do is we'll bring him back in 2 weeks. We'll see what he's done. I'm gonna test you 50 days. Don't use. And I'm giving you a curfew of 9 PM to 6 AM. Do you understand?
Yes, sir.
If I find that you're out past curfew, I will revoke all of your bonds. They're gonna go high. Okay, thanks. All right, take care, Mr. Bullock. James Pons.
Yeah, just got your email about Miss Ford. But it's marijuana, so, I mean, it could have been before. She's only been on bond like a
No,
month.
but I want her to know that I'm gonna test her, so she just can't continue to use. I didn't see what it was, actually, so I'm just
So that's
not.
what I'm saying. What if I tell her, hey, you came positive, there's gonna be another test, the judge can tell if you're using, don't
Let me see.
continue using. I can have her come to court, but I just think the issue's probably that she just was put on bond a few weeks ago.
My only thing is that it bears a little more weight when it comes from me versus just you, but if you want to do that, then I'm with you. But I'm gonna test her 50 days from the day that she took that last test.
I
Let her know.
agree with you, so let's come back Thursday, or I'll bring her Thursday.
Yep.
Because this case is the case.
I'm not
where-
gonna ding her on it, right, but I want her to know that she just can't use.
But her arraignment was a little bit different because we were talking about the probable cause because she was found sleeping in a tow truck.
Oh, I remember the case.
Okay, so that's her. So I had to call her and say, hey, your case wasn't dismissed, even though my argument was excellent.
It was.
Right, they denied our request, so she was like, she didn't have formal, like, she didn't get a reset, I didn't talk to her afterwards, so.
So bring her in, so let's talk, and then.
Okay.
Yeah. Okay.
All right, everybody will be.
Hi, counsel.
Good morning.
Good morning.
I'm here on Mr. David Prado. The case is about 174 days old, so we can talk.
Prego?
Prado, P-R-A.
Okay, I see.
Yes, Judge, I believe the DA's office wants to follow up with the complainant. They're also made an offer to make the case go away with BIP classes, online BIP classes.
BIP.
I'm hoping online because I know this, 18 classes can be a lot.
You see which one?
No, Your Honor.
You do me a favor, if you don't mind, please. Our chief is across the way because they're chiefless in 7. If you can just find out which BIP class it is, and then if it's the online one, we'll give you some time. Whereas we have to micromanage more the 18-week because it's just such a big headache to get it done.
And just for your knowledge, just for this particular case, there are no medical records, no ER, no wounds. I think feelings were hurt more than anything else.
And that's why you probably got the offer you did,
Right, exactly.
I want to know, or do you want to ask? You want to go and ask?
Yes, Judge. I just reached out to him. I'll see if he responds.
Yeah, he's over there now, so.
Yeah, you want me to put him to the side, Judge?
Because I'm giving you different resets based on which one it is. Right? Yeah, because I'm gonna give you, if it's the BIP, the 18-week, I'm gonna give you a longer reset versus the other one. That's why.
Okay, Judge.
Please.
Thank you.
Sylvia. Oh, you need him? Okay.
Judge, may we approach?
Yes, ma'am.
Good morning.
Hi.
Judge, I'm here on an off-docket matter. I have a client that has a warrant. I brought him in to request a bond.
Hey, what's the cause? Oh, this is this. Okay. Did you get the cause number, Steve?
Yes, Your Honor.
Mind bringing him, please? Do you mind bringing him up?
Yes, absolutely. Mr. McLean?
5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-1. 5-
Judge, we have a PSR, so I'll bring it up to you.
Your phone on tape.
Orion McQueen.
PSR.
Anthony's got it. Mr. McQueen, you're charged with indecent assault. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Judge. On April 4th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a sexual assault call and contacting the complaining witness, who stated that her and the defendant, her stepfather, were on their way home. The defendant began talking about the CW's boyfriend and then stated he wishes that she was his so he could, and this is quoting directly, Your Honor,
say it,
taste her, fuck her, and that her innocence draws him towards her. Once inside the residence, the defendant came up from behind the complaining witness, wrapped his arms around her, and proceeded to kiss and lick the side of the complaining witness's neck. The complaining witness attempted to get away from the defendant, but the defendant restrained her until they fell to the floor, and the complaining witness was able to break free, run to her room, and lock the door. The complaining witness is 19 years old.
Mr. McQueen, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. I'm now issuing what's called a magistrate's order of emergency protection. This is a court order that identifies her as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
If you violate this court order, the state can and probably will file a violation of protective order, and that is the capital murder of misdemeanors. Don't pick up a violation of protective order.
Yes, sir.
You're ordered not to have any contact and not to be in possession of weapons. Okay. Okay, so now we need to talk about a bond. Guys, what say you?
Your Honor, due to the nature of the case and the defendant's criminal history, this state will request a $5,000 bond. You said.
What, was that 5,000, Judge? 5,000 is fine, Judge.
Okay, I'm gonna set your bond per agreement of the parties at $5,000. Do you have a bonding company here now?
We do.
Okay, I'll allow you to walk out with your bonding company. Do not pick up any new cases. Do not, he has 2 prior AFMs. One of them against the same complaining witness. Can you please let me know?
Yes, Your Honor, if I can just have a moment.
Yeah.
No, I know. He wants to make sure it's not.
I don't know if, I see
It's
2
not-
AFMs.
it's not the
I'm
same
just
person.
not,
I don't believe it is the same person, Your Honor, from what I have,
Small baby.
case.
Like 10 years ago.
It is not the same complaining witness, Your Honor.
okay. So we'll set your bond at like I said, at 5,000. Don't pick up any new cases. Don't do anything to violate the conditions of this bond. Otherwise, it's not gonna go well for you. Do you understand?
Yes, sir.
All I want is my community safe, and I'm gonna do everything in my power to protect it. So we'll have you now, since reset or no?
Are they posting their own bond?
Yeah,
Then we don't.
yeah, we're not gonna do a reset at this time because what'll happen is he'll get a 7-day, we can't essentially. So once he goes post bond, you will get a 7-day setting. Just reach out to Victoria, email, and then we can give you a further date so you just don't have to come back in a week.
Thank you, Judge.
We'll have him sign all his conditions. Now, do not leave until you sign your conditions, and after that, we'll let you go. And then we'll let him go with the bonding company.
Thank you.
Yeah, okay, thanks, guys. All right. So do you mind filing the MOAB and the conditions, please?
Yes, Your Honor.
All right, Sean, you ready?
Yes, Your Honor.
Hey,
How are you?
what's,
About to go pick a jury, so having some fun.
Are you next door?
An 8.
Or an 8?
Yeah, there's one going on at 7 too, though. So I'm approaching on that, remember we had the Doug Evans plea and there was the superfine issue about whether it should be issued or not. And you had put it in place, but told me to just, bring something back to you. Wasn't sure the exact means about how to address it because I don't think it's on the judgment. So I don't know if it's something that we just tell probation or if it needs to be a pro tunc. But I found the code and how it speaks to the final conviction aspect of it. Because he just started getting text today about having to start paying it.
Okay.
And so I was like, well, let me get in here real quick. And,
Give me a
on
second.
it.
Let me, you know what, I'm gonna also reach out to my staff as well, my staff lawyer to see
Okay.
essentially how we go around.
And can I give you a
Yes,
code section just to have on hand?
give it to me.
Okay, so it is 709-001 subsection B. Yeah, and then that's where you'll see the final conviction language there about it. Okay, great. And if you need me to come back or file or anything like that, feel free to call or.
Let me, because I want to make sure I don't like to do things the wrong way. So let me send an email, give me a couple hours,
Sure.
and then I can get back to you. as soon
I'll
as
try
I-
and come by for maybe on a break or something like that.
Do you have the cause number handy?
Yes, I do. It is 251-8349.
Thanks.
Thank you, Judge. I appreciate you.
Thanks. Guys, come on up. You ready?
Morning, Judge.
Hi.
I'm here on an off-docket matter. It's a request to amend bond conditions that is unopposed by the DA's office. My client, I guess we give the case number.
What's the cause number?
It's 2553235.
Is this on Miss Iwoma?
Yes, it is, Your Honor.
Okay.
Situation is that her husband has been given a promotion and in late May, I think May the 27th, 26th, is being transferred to Blythewood, South Carolina, which is near Columbia, South Carolina.
Okay.
And she would request that she be allowed to go to South Carolina with her husband and appear either virtually at court appearances or be allowed to fly back to Houston for court appearances.
I don't think that there are any travel restrictions now, but it's a DWI second. So she must still comply with the conditions that she has as far as whether she has an interlock, whether she has a scram, whatever the conditions are. I'm okay with her going. I don't care where she goes, as long as she's in compliance with the bond conditions and she doesn't pick up any new cases. That's my only concern.
That's fine.
Did you get the cause number, Anthony?
Do we want to make adjustments to the random drug test requirement?
No, I don't want to do anything special. I mean, she's got to remain in compliance. So the problem is that she may get called upon to do drug or alcohol or drug testing. If she does, she's going to have to go to a Quest diagnostic wherever she is. She could get that done there. I will not accept Punka City, a better drug test, because I want a reputable lab that's ASCLD certified, and I know that's not something where you can just buy a result. And I think that Quest is, pretty reputable. So if she gets called upon to do a drug test, she needs to go to a Quest, and it's on her to get it to you guys, to get it to us, so we know. She's still gonna have to come down. Does she have an interlock or does she have a scram? Well, she's still gonna have to come down to get it calibrated.
Okay.
So that's on her to come down to get it calibrated, and I don't know how often. She probably does that like once a month, I would imagine. So she's still gonna have to get that done. That's not something that you can do remotely. So as long as she's in compliance, I'm okay where she goes there.
It's in the calibration period, and you get every 2 months. Could you extend the calibration to every 60 days rather than every 30?
Because then I don't know if she's like out there and it'll take a while for me to, because I mean, theoretically, I'll extend it to 60 days. It's going to get her time to get over here. It takes me at least a couple weeks to get it. So if she drinks on that day, I'll get the violation in 90 days. And then it just,
Sure.
Yeah, so the thing is I can't show you guys favorable treatment that I wouldn't show to anybody else. You know,
Alright.
I want to be fair to every single person. Everybody gets treated the right way. So they're the same way. So I'm not saying no, but you just have to comply with the conditions.
Okay.
It may be more arduous because you're going there, but hey, that's the cost of doing business.
Can she, when her court's appearance is set, she needs to, I'm sorry?
Your appearance is waived.
Oh, okay, perfect.
We waive everybody's appearance. As long as you're in compliance, we may never even see you. Well, this is a second, so it's definitely, you know, at some point, we're gonna see her.
All right, got it. All right, well, that's all we have, Judge. Thank you for your time.
Sure.
Thank you very much.
Hey, good morning.
Great house on your docket again. We worked out a 4-year deferred upstairs. And, he's applying for interstate compact. They pushed us to Monday to get the supporting documentation. Judge, I talked to Mr. Jurisic, by email yesterday. And he's made a time served offer on the DWI here. I wanted to see if that's something the court's willing to accept, but that time
It's a
served.
first, right?
It is a first.
I'm okay with that.
That offer is dependent on him entering the plea on the deferred. So if we'll push to Monday, he's got a plea on the deferred to get he hasn't pled on the deferred because we pushed to Monday so he can apply for interstate compact. Because he's a California resident.
Come up, Mr. Greathouse.
Is that okay? Okay, just check. Probably around the 180 mark, I think it was.
Of course, I don't have a problem with it. Again, you have to be very, very careful. You know, here in our court, we do the fugitive cases. So I handle all the cases here where someone gets arrested in Harris County for an open warrant they may have in any other state, Wyoming, Delaware, California, Oklahoma. If you have a warrant that originates in another state and you're arrested here in Harris County, I handle all those cases. One of the cases that is most difficult and frustrating to deal with are the interstate compact cases. Because, and she's shaking her head over there because it really is, she's our fugitive prosecutor. Because if you do something to violate conditions where they have to issue an interstate compact warrant and you end up in jail, you will sit there for months on end waiting for anything to resolve, waiting for the interstate compact people to do whatever they need to do to resolve cases. So if you are getting on this deferred upstairs, which is a very serious deferred, right? And you violate conditions and they have to issue a warrant, you could be months upon months sitting in jail. So the only thing I'm trying to tell you is take it seriously. Don't take it as a joke. Everything is done on timing, so you got to do stuff on time. Don't take off. It's the worst thing that you could possibly do when you're on a deferred. Just do what you're supposed to do, and everything ends up well. When you don't, on these interstate compact cases, it's a complete nightmare. You want Monday?
Yeah, please.
Absolutely. Okay, so we'll push you off Monday and then we'll see you. Okay.
Monday, the 21st?
Hey, hi, Alan.
How are you today?
Good morning.
I'd like to first approach Mr. Milton Eduardo Avalar.
Okay.
Mr. Avalar, we completed the documents. He signed them yesterday, and then he's here today, and we hand signed them. So
you can't
hand sign.
Hand sign. Okay, great. So we'll just give you a normal reset.
Perfect. Yeah. Thank you. And then regarding Mr. Reginald Wayne James, gentleman who's got the new charge for murder. Got an ABI in this court.
You said the last name was James?
Yes, sir. Reginald
Is he in
Ronald
custody?
Wayne James. He's in custody. Yes, sir. And I have a cause number if that would help.
No, I got it now. Okay. Oh, right, the murder case.
Yes, sir. So I can see that the 176 has its next court date set for the 25th of June.
Yeah, we usually do no more than 30 days, just so that no one gets, you know, I am gonna revoke the assault. I'll set it at 5,001.
Okay.
And then let's just do 30 days just to make sure, you know, because sometimes people move stuff up and I just don't want them to get forgotten about. So do 30 days. When we come back in 30 days, if nothing's changed, then we'll give you that date after the 25th.
Sounds good.
Okay,
Thank you.
thanks.
That wants me to go?
Yes, everything, we're good, signed? Okay,
Thank you.
money.
Thanks for your
Thanks.
help. I'm good.
Okay, Alan.
Good morning, Your Honor. I wanted to reapproach on the MOAP for Mr. Avalar.
Okay.
Specifically in the orders, it still says that he is prohibited from going near the residence of a member.
No, I took it off. I took it off.
So that was my recollection, Your Honor.
Oh, maybe we didn't do it on the new one. And the new one, we forgot to do it.
So, Judge, I know that you took it off. I was just, you know, I'm sorry, this was, I just wasn't here when we were doing it. What the specific reason was for taking off the residency? Because my understanding based on the RIP and everything is that they're not together. They're no longer together.
I thought you said that they wanted to have contact.
So it wasn't him, Your Honor. I don't think he's surprised to all that has happened over the last week.
Come up, Mr. Avalar.
Okay, you know what, I see a note, John.
Thank you.
We're good?
Yeah, I didn't see the note from the.
So, because I thought that they're still together.
I don't know about the fire or any of that stuff, Your Honor, so I think.
Right, that's because there was a fire, he was going to help her or something like that, and so that's why the new case is.
Yes, I'm aware about that part. I had contact with her, I think a few days before, John did, and I didn't see John's note in there, so my apologies.
Thank you.
Thank you, Your Honor.
You can just write this one, Judge, and I'll make copies, because I'm gonna have to paper file.
So do it on this one or?
You can do it on this one.
So look. Is this something?
We can do that, but I know that this will only last 16 days. After 16 days, they're not going to follow this. That's how so, I mean, we can keep it though.
But I've still got it on the other.
If you have it on the bond conditions, they.
Yeah, I've got it on bond conditions.
You can sign on this one as well.
Miss Wright.
And I'll give them.
Good morning. How's it going?
Well, I wanted to approach and, I know the DAs have kind of moved around. Let me get my case number. My phone just did something silly. It's Andy, Cruz. Pulling it up. I'm sorry. My phone did something done.
Okay.
I asked the DA, I know that they issue, with the, blood, I mean, the breath. And so, they're going to eval for a dismissal, and I just want to see if we can maybe do a couple of weeks.
Well, it's 193 days old.
I know.
I'm getting harangued because all my cases are way too old. I mean, how long did it take you to eval the case?
Not long, Judge. I just need to, I just need to get with our blood experts and figure out the
Okay,
exact, once I get the extrapolation back, so it shouldn't take them more than a couple of days to get back.
well, it's gonna give you at least a week. You know, the week and then come back and then, I mean, if this is something that your client's also willing or wanting to do PTI, Elena, if you can have him also start working on the packet just in case,
Yes, sir.
you know? So let's do a week and then come back and let us know whether you want to go forward or not.
Sounds good. Thank you.
Thanks. Guys, you ready? Or no?
Oh, we're good, Your Honor.
Okay.
Thank you.
Ms. Hudson, hey, good morning.
Asking for the first one, I have two.
Okay,
Requesting a reset date, we submitted her mitigation packet back in March, on March 25th. And from my understanding, we're still waiting on the state to review it and give us an
Have
answer.
do you have everything?
Your Honor, I believe they do have everything.
Okay. I'm gonna do a week. It's 205 days old. So 1 week must appear if there's a decision, so that we can send for a TRAS. If they say no, then here to take care of the case. Who else do you have?
The second one is Crystal Gonzalez.
All right,
And I was actually informed today that she's accepted into the PTI program, so we just need to get her contract,
Is
paid.
she, okay, so you've done everything. So do you have the contract yet?
I do not have the contract yet. He just told me that she was.
Why have they not sent the contract? It's 262 days old.
Sure, it looks like they approved her today. They approved her today, so I'm not sure, and the TRS is still pending.
So it's a schedule.
Hey, can you tell me if the TRS is done on Crystal Gonzalez? Okay, then I'm sending her right now.
Yes, sir.
Is she here?
Yes, she is.
Okay, we need to send her right now.
Yes, sir.
We need to send her, please, for a TRS. Let's set it for a couple days, maybe like 3 days, so that we know that it gets done. And then we'll fast track it to Ms. Gomez. That way they have it and they can get you the contract, okay?
Yes, sir. And will her parents be waived, for that date?
If it's done, yes, okay?
TRS
If for
is-
some reason she doesn't get it done, then she's got to be here and she's got to, we're setting up a trial or taking something.
Okay.
But I'm like literally fast, it's 260 days, so I'm fast tracking this as much as I can. So if she gets it done, we'll set it for, I guess, Monday. Okay, appearance waived. If she doesn't go get it done today, then it's plea or trial. If she gets it done, we'll set it to get the TRS and then send it to them and then to get you the contract that day.
Yes, sir. Thank
Okay?
you.
Yes, ma'am. Hi.
Hi, may I approach your?
Please. This is on Helsinki. Al-Salkini.
Yes, Your Honor. That's the only issue we may run into. Your Honor, we have reached a resolution in this matter. The state has made another offer, which my client is interested in. However, I'm taking into consideration the language barrier here. I'm not sure, but I have to
But I have
double
a
check.
translator.
No, I'm saying, he understands that an offer is a BIP class. The thing is, I'm trying to see if the BIP class is offered in Arabic. That may be the only thing.
It's an online?
Yes, I'm quite sure they can.
Hold on.
Yeah.
It's an online bid class?
Yes, sir. I haven't seen one, so I didn't want that to be an issue when it comes to timeliness.
I usually have experience on these courses. Usually they provide an interpreter.
Okay. They'll
Even
provide
for even for the classes.
Okay. Is that something we have to request prior to?
Yes. Yeah.
Okay. Okay.
For each class.
Okay.
I'm sorry to just interrupt. I was
That's
just
okay.
sharing my
That's all right.
experience.
Okay. Because most of them I've seen are English or Spanish, but I didn't know if that would be.
Arabic and French too.
Okay.
So how are we gonna get that done? I mean, his case is 227 days old. I'm gonna give you guys a couple weeks to get it done.
Yes, we can figure it out. I'll figure it out.
And then I'm gonna tell him I'm setting his case for trial.
I'll figure it out.
So-
If she gave a possible alternative as far as getting an interpreter in to assist with the course, so I can.
Mr. Al-Salkini, come up.
I didn't know that was out there, an option.
Okay, guys, I'm gonna have a translator interpret, so please keep quiet. Okay, Ms. Kuja, thank you for coming. Will you raise your right hand? Do you solemnly swear to interpret word for word what transpires here?
I swear.
Okay, thank you. Mr. Al-Salkini, you are charged with assault of a family member.
مرحبا أستاذ السكين أنت هنا اليوم بتهمة الاعتداء على أحد أفراد الأسرة.
Your case is old at 227 days.
ملفك قديم هو 267 يوم.
It appears that you have worked out a plea bargain agreement that you wish to accept.
حضرتك اتفقت على يعني إدانة اللي يعني ناقشت إدانة واتفقت عليها، حابب تتفق على هذه الإدانة؟ Yes.
Due to the age of the case, I'm giving you 2 weeks to complete this class.
بما إنه الملف قديم راح أعطي حضرتك أسبوعين من شان تخلص الحصص.
If it is not complete, your case will be set for trial.
إذا ما تم انتهاء أو استكفاء الحصص بأسبوعين فراح أرسل ملفك للمحاكمة.
Okay, so we'll give you whatever day you want, and then we'll see you in 2 weeks.
Yes, sir.
Okay.
Thank you.
All right.
Happy
Good luck, sir.
holidays.
Thank you, so.
Thanks. Thank you. Okay, thank you, Ms. Kuja. You're excused.
Thank you. Have a great
Thank
day.
you. Hi. Yes, ma'am. Hi, good morning.
I was appointed to Mr. Mendoza on your in-custody docket.
So I'll ask you.
He has 2 cases of assault, family violence that was a prior bond forfeiture, and a failure to ID. I was appointed this morning on those cases and we have filed bail orders.
Okay.
On the older, we're requesting PR bonds, sir. On the old assault, family violence, he did let me know, he was in communication with his attorney and the his appearances were being waived over in ERD court. I do show a reset from July 1st saying he doesn't need to appear and setting it for July 3rd where he does need to appear and his signatures are not on it. And he said he did not know. But
He picked up a felony violation of a bond condition.
that's correct, Your Honor. That was filed as a to-be warrant.
I don't know anything about the cases and I haven't spoken to him in a very long time. Does he speak English?
He does, yes, sir.
Great. I'm going to have them. Is he bringing him up? He has not made bond on the felony case, so.
That's correct.
Good morning, Mr. Mendoza.
Morning, sir.
Sir, you're charged with 2 cases with us. You were charged with assault of a family member. You're now also charged with failure to identify oneself to a peace officer while being a fugitive from justice. That allegation kicks it up to a Class A, so you're also facing a year in jail and/or a $4,000 fine. This case the assault is a year old. I have no idea what is going on with it, so I'm gonna have you refresh my memory real quick. What happened, please?
On the AFM?
Please. On all 3.
So on the AFM, which is the original charge, on April 6, 2024, officers spoke with the complainant witness who stated she was involved in a physical altercation with the defendant after the defendant became upset with her over food and struck her several times with a closed fist in the nose and mouth, causing her pain and visible injury. Officer observed the complainant witness to have a swollen bottom lip with a small laceration, and she was holding a bloody towel that she used for her nose. Defendant was identified by his Texas driver's license, and the defendant and the complainant witness have been in a dating relationship for 8 years. So that's the oldest AFM. Do you want me to do the felony?
Yeah.
Okay.
What?
So on the felony, on June 4th, 2024, officer responded to a disturbance call and spoke with the complaining witness. Complaining witness stated the husband threw her on the wall after she called his mom to complain of his behavior. Complaining witness said she had a protective.
I didn't hear any of it.
Officer, on June 4th, 2024, officer responded to a disturbance call and spoke with the complainant witness. Complainant witness stated that her husband threw her against the wall after she called his mom to complain of his behavior. And then she stated that she had a protective order against the defendant. And then the failed to ID on April 11th, 2025, officer dispatched to an unknown disturbance call for service. Officers arrived on scene, knocked on the door. Officers observed a male come to the door, but quickly move out of the way, not wanting to answer the door. Officers observed the defendant walking out of the door, stating that he was only having a verbal argument with his wife.
So
Officers-
now a new fight with, and that's what brings the cops to the house?
I believe so. Officer spoke to the female on scene. Officer stated the female was not answering questions due to not wanting to get the defendant in trouble. Officer observed the name and date of birth the defendant provided to officers for not coming through a TCIC search. Officers advised the defendant that if he does not have proper name and date of birth, he'll be charged with failure to identify. The defendant then confessed and provided his real name and date of birth. The defendant stated he did not want to go to jail for a warrant that he had. And then the officer observed that he had a felony and a misdemeanor warrant.
The reason I'm trying to, you speak English, right?
Yes, sir.
The reason I'm trying to figure what's going on is because she's asking me to give you a PR bond, but we've given you bond after bond after bond. You've been in flight status for about nearly a year. And now when the cops come to try to talk to you, you try to evade again. You know what I mean? Are we just going to continue to give you chance after chance? You continue to you just don't give a shice about bond conditions, man. Really? I mean, you know, I get it that he may have not signed it or whatnot, but you can't just be out of sight, out of mind for an entire year and expect good things to happen. So, I mean, really, we've given you PR bond after PR bond. It would just, at some point, I have to say when, so that you know we mean business. There's no more revolving doors, you know? Really?
Your Honor, the original AFN, it looks like they did do a RIP call. The complainant advised that the reason that she had a bloody nose is because she does drugs and was doing cocaine. He did have the PR bond. The VPO was a 2D warrant, so he wasn't given bond and didn't come on that one.
Yeah, but he had a warrant sought for both. Apparently knew about them. So I'm
Well,
not.
it didn't say that he knew about the felony warrant.
Well, I don't know,
He had
but
a warrant out.
But you can't make believe that he knew.
I mean, I can, if you want a bond reduction, I'm willing to give you a bond reduction. I'm not gonna give you another PR bond, dude. Really, I'm just, no more PR bonds. And you know, you've got these cases out. Just, you can't out of sight, out of mind. And the only reason you're here now is because you got into another damn argument. So, Mr. Mendoza, I am now issuing another protective order on this case. And I want you to understand that the Texas Constitution does not allow me, but in extremely limited circumstances, to have a hearing to hold someone at zero bond. This is now one of those cases. If you continue to violate protective orders, we can have a hearing to hold you at no bond. Do you understand? I don't want you to have contact with this person. No means no. Doesn't mean, please, baby, get me out of jail. Every phone call is recorded. Take note when you're making phone calls. Every phone call is recorded. Do you understand?
Yes, sir.
I'm not asking for much. All I want are my streets to be safe. And if you can,
Yes, sir.
so just don't have any contact, don't have any weapons, and that's it.
Sir.
If you want a bond reduction, I'm happy to give it to you, but I'm not gonna just continue to give homeboy PR bond after PR bond after PR bond. Just not, you know?
Would the court be willing to reduce the bonds to $1,000?
I'll cut it in half. So on the assault, 2,500. I'm gonna leave the failure to ID as is. But I'm telling you now, I don't know if you're gonna get out, but if you do, there is a residential restriction. You cannot go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
No alcohol, no illegal drugs. You will be randomly tested. No contact and no weapons. Do you mind? All I need you to do is file the MOA because we'll have him, pre-trial is going to, make sure that you're in compliance. All right, Mr. Mendoza, so what we'll do is the felony case is set for June. So what we'll do is, I don't like to set the people for more than 30 days, so you just don't get forgotten about. We can set you for 30 days, come back, and then, go from there. Okay? All right. Yes, ma'am. Thanks. Do you guys know how to sign a motion to revoke or motion to adjudicate? Anyone?
I can do that, Judge.
You know, yeah, great. There's one in there, please. Hi.
Good morning, Judge.
Hi, come on up. Let's dance.
We are approaching on Mr. Cassius Bond. He's in custody, fugitive case.
Bond?
Bond.
Bond wants a bond?
No, he does not. He signed a waiver. We're approaching to see if you want to admonish him, which I think he would need.
This stupid computer.
Judge, I've had the same experience all morning.
It's like we're already fighting enough, now we have to fight the computers too? Really?
Okay. Is everything in?
This is something, it must be giving me someone else's. I'm seeing like a reset, an attorney of record, bail condition for, that's a costa.
Bless you.
I can't even open up my envelope box to.
That's usually if you got it.
So what's the problem? What happened? Because I can't look at anything. Nothing's working.
Judge, he has cases from Tennessee. I'm not sure that's what you're asking, but he hadn't signed a waiver yet. We just got that
Okay,
signed.
so yeah, do you mind bringing up Mr. Bond? Cassius Bond? No, Bond is the last name.
Okay.
Thanks. Let's do this. Maybe if I entered it manually. All right, so theft of property, identity theft times 10.
Yes.
Fraudulent use of a debit card, 60,000 to 250,000. Wow. And he's on deferred for burglary of a habitation.
That I believe he just took. Yeah, he just.
Yeah,
And he wasn't aware that he had a hold whenever he took that offer.
Good morning, Mr. Bond. Shh. So the reason I'm bringing you out now is you need to make a decision on what you would like to do. You are wanted out of the state of Tennessee, specifically the county of Rutherford, for theft of property, 60,000 to 250,000, identity theft times 10, fraudulent use of a debit card from 60,000 to 250,000. You're wanted for those whole host of charges. There are two things that you can do. Well, specifically three things. So they want you. You can either waive extradition. If you waive extradition, we give Tennessee 14 days to come get you. If they don't come get you within the 14 days, Harris County releases you. If that happens, that warrant will always remain in effect. And it will always remain in effect until you go back to Tennessee and take care of it. The problem is if you don't, at some point, it's going to hose you because you just entered into a deferred upstairs on a Berg hab. So if you are in the middle of your deferred upstairs and then all of a sudden you get taken there and you spend 2 years there, you're gonna get hosed on this probation here. So the idea is that you try to take care of everything now while you're still have the understanding of upstairs. Do you understand?
Yes, sir.
The other thing that you can do is you're gonna request a bond, but I don't know if I'm gonna give you a bond, you know? The other thing is you can fight extradition by saying, you know, hey, it's not me, they got the wrong person. So what I can do is I can, you know, put you back now, have you talk to the lawyer that we've appointed you to see what you want to do. Okay? Do you have any questions?
Yes, sir.
Okay, I guess let me know what you want to do and go from there. Yeah, okay, thanks.
Thank you, Judge.
Thanks.
We're having the bills assigned to.
Okay, you need me to sign it? Yes, yeah.
Arraignment was set
I just
for
passed for yesterday.
the day after we said it, not it, it's still.
Who, 5,002. Hey,
Hi, Judge.
hey,
He signed the waiver.
Okay.
We are gonna roll it to the 17th to see if he wants to keep it or if he wants to ask for a bond. I'm gonna do a little bit more investigating, talk to his family, see what's going on in Tennessee, see if there's anything that I can do on my
yeah,
end.
absolutely.
And I'll go ahead and submit this today.
Yep.
All right, thank you.
Time for you.
Yeah. Thank you, Judge.
Thanks. Okay, yeah, I'm ready.
Next one is.
I'm trying to unsign it. So slow.
Right now, okay,
The next three are set for dismissal.
Yeah.
It's everything's moving like at a snail's pace.
I'm right here, Judge versus review and open. Okay, that's the thing is. Yeah.
Okay, to unsign it. Okay.
Page 7, J. Alvarado.
Judge, I'm here on that one.
Okay,
Judge, so this case was simple enough, class and dismiss. The issue is it turned complicated because she took the class, scored 53, and so she didn't pass it.
what is this? What class did she take?
Anti-theft class.
I mean, really, it's not that hard of a class.
Here's what I could say, Judge. A lot of these clients are from Latin American countries.
They have them in Spanish.
They do, but even then, they're not, a lot of them have very little education.
I'm willing to give you another week.
Oh, perfect. Okay.
Okay,
Yeah, I'll tell her.
another week. If she doesn't have it done, she's got to be here.
Okay,
I'm no more waived appearances.
understood.
So 1 week, must appear.
All right. Get that done. Thank you, Judge. And hopefully she passes it. All right. Thank you.
The next one, Judge, the 1 week brings you out to April.
Ourselves.
Is this, so Thomas was clean?
Okay, that helps, that April 26th.
Yeah, there's nothing negative here.
Okay, great. So we'll do a reset. Same day's felony. Okay, to be tested again.
Thank you. Waiting on a moment.
Right.
It wants to take it forever, so I'm just doing that because they're having network issues. I'll just make copies since, Is Sebastian gonna file the MOAB, John?
Is, yeah, can. What I'll do is, how many cases are you waiting on stuff from Sebastian?
Definitely now, because I heard that. You do paper, I mean, I'll take it. Okay. So we'll get it out of the quality.
Dick, on Thomas, we'll set it for the same day as a felony to be tested again. Yeah, so, guys, Oh, take care, man.
Is it?
Have fun.
Oh, thank you. Thanks, Steve.
Yeah, I told him, hey, so did he ever file the MOA? You know,
Judge,
on McQueen?
he had to go to ERD and is coming out right now, but I am trying to see if I can do it through Cole's computer
Okay.
at the moment, and then after
Steve
that.
has screwed everyone today.
Look inbox is working again. so-
I mean, I don't want him to leave until we get him up signed. I mean, that's the bottom line.
I just didn't know, if you were still there waiting on the body.
Shreya? Anyone else?
Hi, Judge.
That's it? Okay.
I'm
Hey,
here
Shreya?
to make sure, good morning, that Sydney Robinson dismissal's been signed.
No.
Has it been filed?
Yeah, it was signed, Judge.
Oh, it was signed?
Yeah.
I lied. It's signed.
Okay, thank you, Judge.
It's just not entered in yet.
Okay, perfect, thanks.
Fine. What about the gentleman in back? What's your name, sir?
I'm borrowing for him.
Ah, got it. Okay. We're waiting on an order for protection to be filed and the computers are all wonky today, so it's taken forever.
Yeah. Yeah. Should go over here.
Yeah.
Yeah. Julius says, oh, perfect. Those are not-
As well. And then I'll just make copies on.
Hi, Blaze. How's it going?
Got a jury.
Nice. What do you get here? We're done.
Just ready.
Sorry.
Yeah.
We're going to start with the matter of People versus Joseph Anthony Pucci. Can you come forward, please? Right over here, right over here with your lawyer. Good morning, sir. Are you Joseph Anthony Pucci? That's you, sir?
Yes, sir.
Good morning. I'm Judge Middleton. This is file 25518 FY People versus Joseph Anthony Pucci. Mr. Pucci is charged with a felony offense of assault with a dangerous weapon and 2 misdemeanor counts of assault and battery. He has retained attorney Christine Yancey to represent him, and I need to set the matter for a preliminary examination and what is called a pre-exam conference where we discuss the case first. So Ms. Yancey, I'll show a plea of not guilty.
Thank you, Your Honor.
And I will set the pre-exam conference, if this works for you, for April 22nd at 8:30.
Yes, Your Honor.
And the preliminary examination, if needed, for April 29th at 1 o'clock. I don't know anything about this. Essentially, I'm not supposed to know anything about it at this juncture. You have an attorney, she'll get the police report, any video, body camera, that sort of thing, and be in a position to discuss this with the prosecutor. Now, there are some bond conditions. Well, maybe there aren't. I'm assuming there's a no contact with Nathan Clipfell. I don't see it in here, but my order is you're not having any contact with him. Stay in contact with your attorney And I will see you on April 22nd. I don't believe we've ever met before. I don't think you have any criminal record at all. But you stay in contact with your lawyer. Your next hearing will be here at the courthouse on Tuesday morning, April 22nd at 8:30.
Thank you, Your Honor.
All right, thank you.
Thank you.
Christine, I'll take you out, have them take them out to the counter and get your notices.
Oh, okay, thank you.
I don't know, maybe they'll just send them to you. but-
He's coming in Thursday, so I can
Okay.
give him to him.
All right, thank you.
Email to him later today.
All right. Again, I know nothing about that case. There's no affidavit. There's no bond information sheet. They didn't charge felony firearm. He's got no criminal history whatsoever. Ms. Yancey will do a good job in assisting him. At one time, she did a lot of criminal work. She was on the public defender contract for a number of years. Well, let's laid plans. We haven't had a felony trial yet this year or through the first 3 months.
February that started was a mistrial by the actual.
And then we had the Michael Taylor homicide case that got adjourned.
Morning, Your Honor.
Good
Sorry,
morning.
Took an extra minute here.
You're fine.
Morning.
Good morning. You just here for moral support?
I drove her. That's my daughter.
Nobody drove.
Oh, I didn't know that.
Yes, this is my daughter and I drove her here.
Okay, all right.
You go up there by him.
Okay.
Hi, what's your name?
Kiana Hope.
All right. Who's your dad? Clay Sean?
Yes.
All right, I know Clay Sean since he was in 8th grade.
Yeah.
He was very fast. I don't know.
I heard.
Yeah, there were a lot of kids in his class that were fine athletes, and he was one of the best. He went to school with my son.
Oh, that's cool.
Anyway, now here you are.
Yeah.
You're is Kiana Camille Nicole Hope.
Yep.
And you got charged with driving without a license.
Yes.
They wrote this under state statute, Mr. George. Let's take a look at this. It was at 8:40 at night in Sturgis. No, in Three Rivers. Now, why would they write this under state statute? This shit charged as no operator's license. It's a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. Your license is canceled because you got a ticket for driving without a permit that you haven't paid. So let's talk about no ops. No operator's license. It's a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. The normal fine for it is $75 plus $125 of costs for a total of $200. But you got a ticket last March and you didn't pay it. So you're gonna have to pay your old ticket, no matter what we do with this one. How do you plead to the allegation that you were driving a car on March 21st in Three Rivers without a valid license?
Not guilty.
All right, I'll set this for pre-trial, I guess. Are you doing something? What's that?
Yeah, Your Honor, if you don't mind, if the pretrial could be set
If we could give it at least 4 weeks, we're working on some things before she talks to the prosecutor.
All right, are you working on getting your license back? Right, first thing you do is pay your unpaid ticket.
I was not aware of that.
Yeah, you got a ticket in 2023 for driving in violation of a graduated permit. And then you never responded and we sent you a letter and you didn't pay it, so it got defaulted. I think it's $130.
Okay.
So you've been driving without a valid license for a couple of years. You had a permit, a couple things. Getting this ticket paid would help your cause. And then whatever else you can do. So once you get this kind of ticket, you get on what I call the driving suspended merry-go-round and you can't get off of it. If you get this no ops, your mom's shaking her head because she's been on the driving suspended merry-go-round. Then you can't get your license for a year and then you're driving. You got connections in Three Rivers, you got connections in Sturgis. I'm not sure what you were doing in Three Rivers on that night, but don't drive anymore till you get this straightened out. But again, they wrote it under state law, so it happened in the city of Three Rivers. And that was an issue with Sturgis that I don't know if we've completely resolved. If a traffic case happens in the city of Three Rivers or the city of Sturgis, they have an ordinance. And if the fine is imposed, the fine money, a portion of it goes to the city, which helps funds the police department and other services. With a state statute, the fine goes to the state, but then the county prosecutor has authority over it rather than the city attorney. What do you do, Miss Hope? Do you work someplace?
Yeah, I work at Arby's.
In Sturgis?
Yes.
Okay. Good for you. Are you out of school?
Yes, I graduated last year.
Good for you. Your dad was also a good basketball player.
Yeah.
But that was a long time ago. Now it's like 21 years ago. All right, set pretrial with prosecutor. Let's set this out for May 27th. I'm going to send you out to the counter to find out about this unpaid fine. And then I'll ask them to give you a notice. All right. Nice to meet you. Let's see if we can get your license squared away and get you off the driving suspended merry-go-round. Don't drive anymore.
Nope.
Till we get it straightened out.
Yes, sir.
Okay. All right. You're good to go.
Thank you.
The class that Mr. Hope was in had several state championship athletes in it. Some of the records still stand from 2002. The shot put record still stands, beat Paul Leverance's record. The 440 hurdles record still stands. Kyle Shaw. The pole vault record still stands. And maybe the 100-meter dash. I think somebody beat that. And the 440 relay, I think, stood. Clay Sean was one of the guys in that relay, the 1600, the premier high school track event. Anyway, there were a lot of good athletes in that class, and Clay Sean was one of them. All right, that's ancient history nobody cares about, but. All right, our next matter is, what do I do with it? Is in the matter of Ava May Calvin. Good morning. Are you Ava Calvin?
Yes.
Or good afternoon, excuse me. I met you last week. While you were waiting, I was talking with your grandpa and realized that he is your grandpa. So I learned something every day. And so I've known him for a long time. But you are here with your lawyer, Mr. Paul Gibson. I have to get used to not doing this through an interpreter. I just say it. You're charged with assault with intent to do great bodily harm, which is a felony punishable by up to 10 years in prison. It's alleged that that was partially a strangulation. The prosecutor has agreed to dismiss that charge for a plea to the misdemeanor charge of domestic assault. Let's talk about that one. Domestic assault is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. My understanding, Ms. Calvin, is you've never been convicted of any domestic assault charge. Is that correct? And you are eligible for a deferral under a special statute that allows domestic violence cases to be deferred. That means they would be made non-public. There will be no public record of your conviction if you complete the probation. I can only do that if the prosecutor consents. Mr. O'Bear is here from the prosecutor's office. Is that the plea agreement, plea to domestic assault, no objection to the deferral?
That's correct.
You agree, Mr. Gibson?
Yes, Your Honor. And the defendant, it may not, I'm not sure if it's permitted, but the defendant is asking if the court would accept a no contest plea, but she is prepared to plead guilty if she has to.
All right, well, let's see are there children involved here? So is there a protective services case or custody case?
There is an open CPS case.
All right, that may be a basis for a no contest plea. Do you have any objection, Mr. O'Bear?
No. I think it's
Now-
worse for her if she pleads no contest.
What?
It's worse for her if she pleads no contest, given what's gonna be in the police report.
Yes. If you plead no contest, you don't admit what happened, but you don't deny what happened. And you allow or accept that a conviction will enter. And they won't be able to use this conviction against you in another proceeding, custody or CPS, Children's Protective Services. However, I will get my factual basis from the police report rather than your version. The police report indicates that he was getting strangled to the extent that he threw up, some of it in their presence. But that certainly is a factual basis for domestic violence. Do you understand that, Ms. Calvin, if you do enter this plea, you'll be giving up these rights and the right to have a trial and all the rights that go with it? Do you understand?
Yes.
Anybody threaten you to plead to this?
No.
Promise you anything?
No.
And do you wish to plead no contest?
I guess I don't really understand the difference, like what it means for me.
Well, I don't blame you because it's nuanced and difficult. Now, when you're charged with a crime, you can plead a couple different ways. You can plead guilty. You can plead not guilty. If you plead guilty, I will ask you some questions to make sure that you are guilty, that you understand what you're doing. And if you plead guilty, the next step in the process would be the sentencing. If you plead not guilty, We would set it for further proceedings, including a preliminary examination, even a trial if necessary. There are a couple of other pleas. One is guilty but mentally ill, and that's not relevant here. You're not mentally ill. And then there's another one called no contest plea, nolo contendere in Latin, means I do not contest it. And by pleading no contest, you would allow the court to take a factual basis from an affidavit or bond information or police report. Now, this happens sometimes because people don't remember what happened. They were driving their car, they hit a tree, and they woke up in the hospital, and they don't remember anything. Their blood alcohol came back at 0.20, and there's a video of the police following them down the street. So they don't remember that what they did, so they can't plead guilty, but they will allow that a conviction would enter by pleading no contest. Another reason for no contest is if there is some other sort of legal action, like a lawsuit for money damages. This very often happens in vehicular accident and, heaven forbid, vehicular death cases. The person will plead no contest because when you plead no contest, they can't use your plea against you in a civil proceeding. Other civil proceedings are divorce, child custody matters, child protective services cases, where they could not use your plea against you in that proceeding. They'd have to prove it independently. If you pled guilty, all they'd have to show is that you pled guilty. However, the nuanced part of it is then you can't get up at sentence and say, well, this didn't really happen. I plead no contest, but I'll get my factual basis from the bond information sheet and then later the police report. Let me read you what that says. On March 18th, I was dispatched to a domestic assault in progress at Maple Crest Apartments. The caller stated her neighbors were fighting and she could hear a male and female. I arrived on scene and could see a male wearing a black backpack around his neck and a female yanking on the bag. The female was choking him by pulling on the bag with the strap around his neck. As I was approaching, he was gasping for air and puking. While speaking with the male about what was going on, I could see visible redness and nail marks on his neck. I asked the male how the nail marks got there, and he told me that she had grabbed him by the neck while attempting to remove the backpack from him because she said he was stealing her marijuana. I spoke with several other people who also witnessed Ava assaulting Deontay. They have a 2-year-old child in common. They've been in a previous dating relationship for the last 4 years. Now, that is sufficient for me to accept a plea to domestic assault, the 93-day misdemeanor. Is that acceptable to you?
Yeah, yes.
All right. Now, I don't know what happened before this. I don't know whether he was drinking, whether you were drinking, whether there were other drugs involved. But I know that is sufficient for this plea. I won't sentence you today. The law requires in these kinds of cases, I set it out for sentencing at least 10 days from now. And I give him an opportunity to tell me what he wants me to know. Let me ask you a couple of questions. There are no contact provisions, correct? You and Deontay can't have any contact. Who has the children?
I have my son.
Who's at the Maple Crest address?
I am.
And he is someplace else.
Correct.
All right, I think that's what you told me last week. All right, so you're in your own home, you've got your children, and we are not in an urgent situation because you're not also in custody. Let's find a date that works for your lawyer. I'm going to be gone for a little bit. And I've got all my sentencing days crammed full including Mr. Gibson's got several cases coming up. I'll be gone from the 11th to the 21st. I thought about the 23rd of April. The 28th of April is crammed full. So is May 5th. We have a lot of interpreter cases which take a long time. But I believe we can do it on Monday, May 12th at 10:30. Does that work for you, Mr. O'Bear?
Yes.
Does that work for you, Mr. Gibson?
Yes.
Monday, May 12th. Maybe it'll be warm by then. Need victim input and police report. Ms. Calvin, do you work someplace?
I do.
Is this going to be in the middle of your work hours?
I'm normally scheduled off Monday, so I think it'll be all right.
All right, very good. What do you do?
I'm a pharmacy technician.
Yeah, your grandpa told me that. Who do you work for?
Fred's Pharmacy.
All right, good for you. They do more than a lot of pharmacies there. They do compounding and other stuff.
Yeah, it's pretty lovely. I was working at retail pharmacies before, and this is my first independent pharmacy. It's so different.
All right, this matter is set for Monday, May 12th. Now, the no contact provision is still in effect. The other conditions of your bond are in effect as well. So I don't want to have any more bad stuff happen between now and the time we do this. The prosecution has no objection to your deferral, in which case on that day, I will most likely be placing you on probation and sending you to the women's anger management treatment class with some other conditions. At that time, we can discuss whether we lift the no contact provision or not. Do you have any questions?
I don't think so. Probably have more.
All right, stay in contact with your lawyer. We'll have a whole other opportunity to discuss this at the time of your sentence. All right, you're free to go.
Thank you.
Thank you, Mr. Robert.
Thank you.
This is a brief record in the matter of People versus Quincy LaShawn, Washington. The file number is 24705OT. It's an ordinance case from the city of Three Rivers. Mr. Washington, this is got a lot of baggage in it. He missed some other dates and called in and didn't come. And anyway, he was charged with driving suspended under city ordinance. He has a very heavy driving record. And the prosecutor agreed to reduce it to allowing another to violate the motor vehicle code. So that plea was entered. It is a 90-day misdemeanor. Mr. Washington owes $575 of previously unpaid traffic tickets, which used to require that you be suspended. So I set this matter for sentencing some time ago, January, and gave him until April to pay his unpaid tickets, and set the matter for sentencing today. I said that at a special time of 4 o'clock. We don't usually do sentences at 4 o'clock. I didn't want him to miss work. Mr. Knopfinger drove back over here from Three Rivers for this sentence, and Mr. Washington hasn't paid anything. He hasn't shown up. He did contact the court, but didn't pay any money. So this file is full of him not showing up at the right date at the right time. I sent this date especially for him. His lawyer came back here. The defendant failed to appear for sentence. Failed to appear, failed to pay tickets. issue a bench warrant in the amount of the unpaid tickets, $575 cash or surety, 48-hour hold. I know Mr. Washington and his family watched this live feed, very disappointed that he didn't appear for this. I think maybe he was afraid I was going to put him in jail because he hadn't paid his tickets, and I guess that was a possibility. Now it's even more of a likelihood since he didn't show up for sentence. So, Mr. Knopfler, any further contact for Mr. Washington?
No, Your Honor.
Yeah, I gave him 4 months to pay, and I don't think he paid a penny other than call the day before. And the clerk checked just instantly, and he hadn't paid anything. And more importantly, he isn't here. Bench warrant, failed to appear, $475 cash or, oh, I'm gonna do cash only, yes, pled. Or see judge. Then he'll still owe a fine for this, or maybe I'll just, I don't know. I didn't want him to lose his job. I set this especially for him, and he pimped me. All right, Mr. Washington, you need to get a hold of your lawyer, or you're subject to being arrested on a bench warrant. That completes our day, and we'll be back tomorrow with a criminal docket.